Okay, this is Chapter 4B, talking about the trial and post-trial motions. The trial itself is a formal process of presentation and cross-examination of evidence by both parties. If one party completely fails in its proof on its side of the case, then the court may order a directed verdict at the end of the trial, which is a judge's order to require a jury to return a specific verdict. It's very rare that this happens, but that's when one side completely fails in its case. If there's no question as to the adequacy of either side's presentation of evidence, then the court, after closing arguments, will instruct the jury as to the law. Remember, the jury determines facts and applies those facts to the law, and the judge is the one that determines what law is applicable. So you have your closing arguments, and then the judge will give instructions to the jury, and sometimes the jury will ask for a repeat of those instructions. It is a contest between both sides as to the jury instructions that will be given to the jury. Each side is wanting instructions that will favor their position. So based on the evidence, the jury instructions that the judge has given, then the jury will give a verdict on one side or the other. And that is determined as to who is the winner in the case. The jury, in reviewing the facts and applying the law as given to them by the judge, so the key decision of the jury at the end of the trial is to determine if the one party or the other has met their burden of proof. The plaintiff is the party that has the burden of proof in a lawsuit. Which party has the proving of the key facts, by what standard, as to what degree of certainty that these key facts must be produced. In criminal cases, it's beyond a reasonable doubt. This means that the facts as presented at the trial are more likely than not to have been present in the case. And they have to look at it and say it is beyond a reasonable doubt. In civil cases, however, the burden of proof is only a preponderance of the evidence, like approximately 51% of the evidence favored one party, favored the plaintiff, because the plaintiff has the burden of proof. And therefore, if they don't meet that, then they will not win, and basically the defendant will end up winning the case. The judgment in favor of the party, the trial court is one last chance to correct a jury's verdict after the trial if the court finds that the jury completely missed the boat as to the evidence or misapplied the law. In such circumstances, either party may ask the court to enter a judgment notwithstanding the verdict. It's called JNOV, which would essentially counteract the jury's verdict. Again, not done not very often, but at times a judge looks at it and says the jury was completely off base and will end up giving a judgment notwithstanding what the jury said. Of course, that will generate an appeal from the losing side, because they will almost always say that the jury made a decision and the judge overstepped his or her boundary. Okay, so we now come into the post-trial time. Once the litigation procedure is completely at the trial level is completed, the parties have the potential to seek further decisions on legal issues from the appellate courts through the appeal process. Notice I said legal issues. A party may not dispute the factual evidence and may not introduce new factual evidence on an appeal process. Appeals are limited to addressing legal issues, meaning the questions as to whether the law was correctly used and applied. Of course, one of the legal issues is, did the judge allow all the evidence that's legally allowed to be in, or did the judge legally allow evidence that should not have been in? While those are factual issues, that the discussion is about, but maybe the jury should have or should not have seen that or heard about that. So the appeal cannot attack the facts that the jury determined, but it can attack whether those facts should have been made available to the jury. Appeal courts typically give significant deference to the trial court determinations on the facts of the case. You then come into the enforcement, which doesn't do any good to win a lawsuit if you don't collect. As it's often said, anybody can sue. The question is, one, can you win? And two, can you collect even after you win? So you have enforcement, you have execution of the court decision, and then you have various garnishment rights that a winning party may go against the other party trying to collect assets or income that the losing party has. There is a doctrine of res judicata, which basically says that a case that has been determined cannot be retried. And so that would be one of the motions early on if a party on a trial tried to retry it other than through the appeal process. Okay, here's a quick pop quiz for you. A directed verdict refers to the power of the court over parties involved, the power granted to litigant to reject jurors, the power of a court to order sworn questioning of witnesses outside the court, the power of a court to grant a decision in favor of the defendant when insufficient evidence is presented at trial. What is the correct answer? The correct answer is D, the power of the court to grant a decision in favor of defendant when there is insufficient evidence presented at the trial. The power of the court over the parties involved has to do with jurisdiction. The power granted to litigant to reject jurors is part of the voir dire process of accepting or rejecting jurors. The power of the court to order sworn questioning of witnesses outside the court is the part of discovery, and that is part of the deposition process. Okay, that's all for Chapter 4. Thank you very much, and we'll be moving on to the next section next week.